before we broke, I referred you to the paragraphs of the CMA decision, paragraphs 5.37b and 5.38, core bundle 3. Sorry?
Core bundle.
No, I won't take you to those, but I remind you for your note, I took you to those in opening.
537b and 538.
538. I took you to them in opening, and they made it clear there are several ways in which compliance can be achieved with the directive, including ex post amendments to the tariffs or mid-year tariff changes.
Yeah.
And I made the point that that's exactly what was proposed by SSE and EDF in 2016 with CMP 261. And I would like to take you back to the document that Mr. Beale took you to yesterday, which is Core Bundle 2, tab 23.
Tab
23.
Yep.
Right at the very back, page 526, please. Paragraph 24, which Mr. Beale took you to, and it explains there that SSE foresaw, this was in the context in 2016 of CMP 261, foresaw that the increasing level of charges would lead to it paying charges which exceeded the legally permissible limit. Rather than seek to recover charges levied in breach of EU law and ex post, it chose to raise CMP 261 in March 2016. And then you see about halfway through that paragraph, CMP 261 therefore proposed a modification to allow a mid-year tariff modification.
Oh yeah.
In spring 2016.
Explain that as being to avoid the need for an ex post facto.
Yes, it can be done at the end of the year, it can be done mid-year.
That the ex post facto assessment would have been an alternative, albeit not a very satisfactory one on the facts of that.
Well, at that stage, this is 2016, but it's always been open to industry and open to GEMA under CUSC 817A to modify or make tariff modifications, raise tariff modifications either mid-year or at the end of the year. Final point on this for the record, GEMA also made clear in its decision that's at issue in this case that it required NGESO to carry out ex post reconciliation to ensure compliance with the permitted range using the correct definition of the connection exclusion as set out in Annex 2 to that decision. And if I can take you finally to the decision, back to the decision, Supplementary Bundle 2, tab 14. Page 269. And if I could ask you on page 269 to read the paragraph under the heading Historical Compliance with the Limiting Regulation towards the bottom of that page, about halfway down, just over halfway down.
Thank you very much. Thank you.
269, just under the heading Historical Compliance with the Limiting Regulation. So this has always been an option. It's in the public domain. SSE clearly knew about taking this approach, did so with CMP 261.
Well, and they're also saying that the view had been taken that there hadn't been non-compliance in previous years.
Absolutely, because as you will have seen from the CMA decision and from GEMA decision itself, as part of the decision, GEMA asked NGSO to provide it with the figures, the relevant figures to enable it to make that assessment. But it did ask NGSO to consider specifically the position in the current charging year, that's 2020-2021, to see what the position was.
And it's relevant also, I suppose, in that when one's looking at a remedy to cure past breach. So you're not limited to just remedying the previous charge year. You look at it historically for however many years there might be in breach. You can, from the point of view of good administration, ensure that there is reconciliation as far as it needs be.
Absolutely, and this is exactly what
reflects this, yes.
So
And I asked you whether
yes, my lord.
Adopting the ex post reconciliation provisions of course 1417 that we looked at page 214 of tab 12, whatever this is, supplement, prohibited the sort of ad hoc ex post adjustments that are referred to in paragraph 537b.
And the answer, my lord, is absolutely not.
So what is
The ex post these adjustments are modifications to the CUSC. So it would be a modification to the CUSC either raised by an industry party, as it was for CMP 261, or raised by GEMA under 817A.
And it would always be done through the CUSC into 817A. I mean,
817A can be, yes, I mean if it needs to be done quickly, probably the quicker route would be 817A when, although it would still need to have some industry consultation for reasons, and I can develop this point, but essentially for reasons of good administration, for reasons of consultation, etc., there would need to be some consultation.
There has to be, it takes time.
And of course charges are not immediate. Your charges are set for a year, and there needs to be some predictability in industry as to what charges they're going to be paying. So yes, it's not instantaneous, but there are reasons why there has to be some sort of process and it's done on a charging year basis.
And an alternative to using 817A could be enforcement proceedings against NG under its licence. I mean, you may view that as heavy-handed, but that's not the only method of securing compliance.
It's not the only method of securing
I'm
compliance,
not trying to scare anybody by suggesting that, but that would be another method. If there, I presume there is some obligation on National Grid to comply with the law. If it didn't do so,
yes,
enforcement proceedings.
yes. I mean, but I think that would be very much a last resort for the regulator who needs to work with NGSO.
Yeah, understood.
Just on this point as well, I just looked at 537B again,
Yes.
and strikingly in the footnote, the CMA actually recalled the fact that the appellant's SSE had accepted that there were a number of ways in which you could affect an ex post facto ad hoc modification.
I think it would be difficult for them
various
not.
different things.
Yes.
Didn't have to be.
Well, and they did it at CMP 261.
Well, they've
so
done it in relation to 261, I agree. But it's just an express recognition of that.
My lord, I'm grateful, yes. So just final point to
Sorry,
tidy up.
I'm just trying to get
Yes,
the
sorry.
framework. It boils down ultimately to this, that putting it back into the framework of the issue we're looking at, your stage 2 was cure by some appropriate means for however long it takes and for whatever period is required. That's your bottom line.
Yes.
Stage 1 is you take the NG proposal. Stage 2 is you then work to produce a final result,
Yes.
and you have the ability, you have a variety, you have flexibility to achieve whatever result is appropriate in the light of your interim solution.
You take the original proposal because you think that's likely to lead to a situation where you won't have to carry out ex post reconciliation. But if it does, then there are options open, and you have made it clear that you will use them. Or we have made it clear that we will use them. So just a couple of final points on the back of what Mr. Beale said this morning. Mr. Beale said that if ex ante tariffs are set on the basis of the wrong interpretation of the connection exclusion, that would give wrong market signals. And we say that's incorrect, particularly on the facts of this case. The directive clearly sets ranges as long as generated charges fall within the range, the correct market signals are given. And GEMA's decision was that the original proposal would ensure that charges fall within the range.
The signal coming from the decision is we'll get it right one way or another at the end of the day.
And we have made a substantial step towards ensuring it's going to be right by making this decision.
But anybody looking at that wouldn't necessarily assume that the interim solution was the final solution.
No.
They would see it as a direction of travel.
Exactly.
If you're going to make an investment decision on that, no doubt you can do your own calculations. But But I mean, in terms of signalling, it is a step along the way.
Well, my lord, it is, and your lordship this morning said to me that I think to Mr. Beale, that the GEMA decision did not quantify the serious and imminent risk of breach which would result from the status quo. But in fact, my lord, it did. And if I can ask you, if you have the decision still open, it's on the top of the page 263.
It does there. I mean, yes. I mean, that wasn't. There's a sort of quantification there.
Yes, but my lord, there.
Just to decide that there would be an improvement on the status quo.
Exactly, my lord, and I think, and also if one looks, and I won't waste any more time, but it is the difference between the correct interpretation and the original proposal of about 1.7 million, I think is also in the decision as well. So we're told that this is not just a step towards compliance, but a very large step towards compliance with a little step after that.
Somewhere you gave us the figure of 1.7 million.
Yes, my lord, I'll dig it out. Maybe while Miss Rogers, I don't want to take up any more of her time.
My lords, with your permission, I was proposing to do 4 things. First, to pick up some of the practical questions that your lordships were exploring with Mr. Beale this morning as to what congestion is and what these services do. Secondly, then, to turn to the ITC regulation itself and to see what we can discern as to the intended scope of the ancillary services exclusion from the preparatory materials that Ms. Smith showed you yesterday. Thirdly, having done that, to look very briefly at the natural and ordinary meaning of the words, as I say they are, as they appeared in the 2009 definition of ancillary services. And having done so, to turn head on to the 2019 regulation and directive and the question, what is meant by congestion management in the recast definition? And to address straight off my Lord Green's question this morning, is GEMA suggesting that the court should disregard the 2019 definition and look only to 2009? The short answer is no. We accept what the judge has said as to that. We say that 2009 and 2019 mean the same thing. And the way we put it is that you look to the 2009 definition to inform your understanding of the words that appear in 2019. And that's the way we put the point. My lords, as to the practical questions that you were exploring with Mr. Beale, it seemed to us they come down to 3 things, and it is worth separating them out. 1, what is congestion? 2, how do you deal with it? And 3, how does that translate into charges and the questions that you actually have to address for the purposes of this appeal? And I'm going to illustrate the answers to those, if I may, by reference to the evidence given by Mr. Self of GEMA, which is in Supplemental Bundle 2. Behind tab 18, beginning at page 358, but the passage I want to take you to, my lords, is at page 368. So, my lords, taking first the question, what is congestion? And as Mr. Beale explained this morning, all of the infrastructure across an electricity network has operational limits. And if too much electricity flows across it, flows through the cables or through the substations, the infrastructure cannot cope, meaning that the electricity flows will slow down, or you may end up with frequency and voltage problems, or ultimately, in a disaster scenario, the cables would melt or warp or simply become inoperative. And that is ultimately the point made by Mr. Self in paragraph 36, that the grid is designed to transport electricity, and to maintain the safe operation of the grid, supply and demand must be balanced, and the frequency and voltage levels must be kept within strict operational limits at all times. Now, my lords, how do you deal with congestion? Well, the answer is different, as you'll have heard, as between the position within Great Britain and as between the position at an interconnector or link between different bidding zones. And taking the position within Great Britain first, there are, as you will have seen, a series of services used by National Grid which broadly involve paying generators to do certain things or not to do certain things. But my lord, there is no bright line division between the services that are used to address congestion in the sense of ensuring that the operational limits are adhered to, and all sorts of other internal issues that arise on the network. And my lords, you see that from paragraph 39 of Mr. Self's statement, which is over the page at the top of page 369. And he explains, the CUSC charges are charges in relation to an aggregation of various services. The nature of balancing services, and I underscore this, is that one balancing action, i.e. one particular service, can be used to serve multiple purposes. For example, imbalance, network constraints, voltage issues. And even where, as he goes on to explain, even where a constraint on the capacity of a piece of infrastructure is the initial driver for balancing action, and even if that means that the costs are internally logged as a constraint cost, in fact, that action may well have, and often will, have resolved multiple issues that are not constraint related at the same time. So we say the services that are at issue, that are the subject of the CUSC charges, are services that solve multiple different functions at the same time, including dealing with constraints, but also a whole package of other issues, including voltage issues, imbalance, and so forth. There is no single bright line defined category of constraint services that is separate from that wider package. And my lords, for your note...
Albeit that they're legally different.
Indeed.
You know, that's the difference between a legal difference and an operational difference. I mean, I'm sure there's lots of blurred edges between the different services, so costs have to be allocated in all sorts of sophisticated and possibly controversial ways, but legally they're different.
But my lord, I see that, but it comes back when your lordship's looking in due course at what is meant by ancillary services. I say the practical reality does inform that you're looking at a package of services that solve multiple issues at the same time. My lords, just for your note, that paragraph 39 from Mr. Self, you'll find reflected in the findings made by the CMA at paragraph 2.12 of their decision, which is at page 545 of Core Bundle 3. That's the position within Great Britain, my lords. As to how you deal with congestion as it arises through interconnectors or the other links between bidding zones, that, as you've heard, is dealt with by the separate EU-driven process of capacity allocation and auction process. And my lords, you see that in paragraph 44 of Mr. Self's statement, at page 370 of the second supplemental bundle. So the means by which Ingesso National Grid balances the GB system and ensure that safe physical limits are reserved do not include the auctioning of available capacity. A different approach applies in relation to interconnectors, where available capacity is allocated to the highest bidder in an auction process known as capacity allocation. And that capacity allocation process is not funded via CUSC charges. So, my lord, standing back and asking how does all of that translate into charges and the issues on the appeal? As to the position in Great Britain, we have this bucket of the CUSC charges.
So can you just unpick that? When it says the different approach applies in relation to interconnectors where available capacity is allocated to the highest bidder. Capacity where?
Capacity across the interconnector. So, my lord, if that helps,
So in other words, if you can only transmit a certain quantity of electricity, you basically auction the right to do that over a certain period.
Exactly, my lord. So, and I'll show you this.
And everybody else has to just back off if they don't win the
Exactly,
auction.
my lord. So, and I'll show you this as it arises in the regulation when we get there. But the process is that all of the different member states work out through a phenomenally complicated process what is the available capacity on the interconnection cable at any particular point in time. And having worked out the available capacity, there is then an auction process in which people place bids to pass their electricity through the interconnecting cable. Some of those bids are successful in a world in which there are too many bids, some are not. And those that are successful have been allocated the right to pass their flows through the cable. That's how it works, Mill.
And so you're there only talking about the costs of the auction process, are you?
You're talking about two things, the costs, the administrative costs of the auction process, together with the bid that those generators have placed in order to secure the capacity. And that bid that they place in the auction to secure the capacity is what is then treated as congestion income within the regulation, and I'll show you when we get there.
If we were looking at the position between Great Britain and the island of Ireland, do I get this right? There'd be as it were, an auction process between various generators to supply electricity across that
Exactly
interconnector into the Republic or into Northern Ireland.
Exactly, my lord. To use the capacity on the interconnector. My lord, standing back and asking how do these charges fit into the questions on the appeal? So far as the entirely internal position is concerned, the pursuos charges, the question for you is, are they within the ancillary services exclusion? And we of course say they are, and Mr. Beale says that they are not. The question of the payments my lord Lord Snowden raises, the sums that are paid to secure capacity through the auction and fees to auction houses and so on, those are not treated as network access charges at all. They are entirely out with the harmonisation regime that we're looking at in Part B of the ITC regulation. So they don't go in at either end of that process. One final factual point, my lord, I think it was my lord Snowden, but certainly the question arose this morning, how does all of that fit with balancing and how do these different concepts relate? I'm so sorry.
Might have been the Chancellor, I think, actually, but
The answer from GEMA's
seems a long time ago.
the answer from GEMA's perspective is that there is no bright line division. So the services that we use to address congestion internally, what we call constraint management services, some of those services are a subset of balancing as it's defined in the regulation, and some of them are a subset of non-frequency ancillary services as defined in the directive. And the capacity allocation auction process is entirely separate and distinct, as I was just explaining to you, Lordship.
That seems to be what Mr. Self is saying in paragraph 39.
Exactly.
Because he talks expressly about network constraints. And I did wonder when you read that to us, because I was still puzzled as to how you could actually draw a distinction between the balancing exercise on the one hand and dealing with congestion on the other, because it seemed that they were effectively
And they're interrelated.
part of the same exercise.
Precisely, my lord, and you can see that just conceptually, because if you pass too much electricity through a system, before you get to the point that the cable blows up entirely and that part of the network goes down, one of the things that will or may happen is the voltage will go out of sync or the frequency may go out of sync. And so all of these issues and the services that are used to address them are absolutely interrelated, and we say that's core, my lords.
But it remains the case that there is a bucket of cost in law called congestion. It may be very difficult to work out what goes into it, and that's a quite separate issue in that regulatory debate between the regulator and the regulated industry. Nonetheless, there is a lawful category of cost, which is, for us to decide, excluded or included. We don't really have to decide what goes into that bucket, do we?
Happily not, my lord.
Definitely happily.
Can I dive straight into that question and take you to the beginning of the story and the question of what you see at the time that the ITC regulation was brought into being? And my lord, if we could turn there to supplementary bundle number 1 and to the guidelines that Ms. Smith took you to yesterday. My lords, as Ms. Smith explained by reference to the impact assessment.
Missed the page number.
Oh, I'm so sorry, it's tab 1,
Yeah.
page 4.
Yeah.
So these are the guidelines on transmission tarification from 2005. And as Ms. Smith explained yesterday, the ITC regulation was intended to reflect these guidelines into law, and you saw that from the impact assessment produced by the Commission. And what was the structure of this document, as you saw, is that there is an explanatory note that begins at page 4, and then the guidelines themselves at page 7. Can I pick up the explanatory note itself on page 4 under the heading Current Situation? And my lords, what you see in that paragraph is this explanation. Transmission tariffs in member states already reflect most of the requirements of the regulation. Pausing there, that's the predecessor to the 2009 regulation. Second sentence, my lords, the main component of the transmission tariffs is related to the costs that are considered fixed in the short run. These charges may be imposed on generators, called the G charge, and for the load, i.e. suppliers, called the L charge. And then over the top of the next page, but also page 5, we see this. As well as the fixed costs of the transmission network in the short run, i.e. capital and operation costs, transmission tariffs often include specific charges for losses, congestion, and other ancillary services. My lords, note there the linkage of losses and congestion, and also the indication that in this context, congestion is treated as an ancillary service, hence congestion and other ancillary services. And the explanatory note goes on, my lords. Generators and consumers may also be required to pay a one-off charge for their initial connection to the grid, usually called the connection charge. So we've now had it separately pulled up the connection charge, charges for losses, and congestion and other ancillary services. And the drafters go on, charges related to losses, congestion, and other ancillary services are also an important feature. These charges are not, however, considered to be part of the G charge for the purpose of these guidelines. And my lords, we say that is what then follows into the guidelines themselves and ultimately the ITC regulation, that there is to be some harmonisation of the G charge, the overall generator charge. It's only some harmonisation, it's got complete harmonisation. But that the 3 categories identified here, losses, connection charges and other ancillary services, including congestion, are carved out from that harmonisation. My lords may ask me, what do the guidelines mean by congestion in this context? And the answer to that, my lords, is that these are guidelines dealing with the tariffs charged internally within member states for access to the national transmission network. And so the reference to congestion here can only sensibly be understood in my submission as relating to charges relating to the management of congestion within a member state. So internal congestion, or in GEMA's language, internal constraint management.
This is an explanatory note which is relevant to the cross-border electricity exchange regulation in 2005. Is it part of the formal travaux to the 2009 regulation or to the ITC or to the?
It is by this mechanism, my lord, and I can take you back to it. The impact assessment that accompanied the ITC regulation made absolutely plain that what the ITC regulation was trying to do was to give effect in law to these guidelines. And so we look to the guidelines in my submission and say, well, what are they intended to include? And the answer is here given. And that follows through then, but it's in my submission, into what you see in the ITC regulation itself. Now, your lordships may also ask me why, what links these categories.
Just so I've got the references for that. So the ITC impact assessment.
That's the next tab.
We haven't looked at it, haven't we?
That is tab 2.
And which is the paragraph which brings in, as it were, the guidelines.
Perhaps most clearly, my lord, at page 45, under the heading Conclusion Tariff Harmonisation, in that square box, in light of the significant support for the adaptation of the 2005 draft guidelines and the extensive consultation process involved in their development, it is appropriate to formally adopt these guidelines, along with those relating to the separate mechanism for compensation that Mr. Beale touched on this morning.
Well, I think Ms Smith showed us the bottom of the previous page and the top of that page,
Exactly.
44 to 45.
Exactly.
Spells that out.
Thank you, my lord. So then your lordships may ask me this, what is it that links those categories of charges that are being carved out from harmonisation? So connection, losses, ancillary services. And the answer again, my lords, is that Ms Smith touched on yesterday, that they are all types of charges that can, in principle, be used to send locational signals to generators to incentivise them to set up in particular locations and not in others. And so, my lords, if a generator sets up somewhere new and remote, and from the perspective of a national system operator wholly inefficient, it is open to a national transmission operator to say, well, we will structure our charges so that it costs you more to connect, or that you pay additional sums for the electricity that will be lost in transit. And equally, if a generator sets up somewhere that adds to the constraints, the bottlenecks on the existing systems, it's open to the national transmission system operator to structure its charges so that those generators pay more in charges for ancillary services. And that ultimately, my lords, is the balance that is being struck in this partial harmonisation in the ITC regulation between, on the one hand, trying to avoid distortions between generator charges in different member states for all the reasons that Mr. Beale explained, whilst at the same time still preserving flexibility for local regulators and system operators to set their charges in a way and at a level that they consider, if they wish, sends the appropriate locational signals. Can I show your lordships that theme in the impact assessment? It's probably just two passages. So this is back in tab 2 of supplemental bundle 1. And picking up, if I may, at page 20. Your lordships have the heading tariff harmonisation, and so you have your bearings. This is part of the section that...
Just so I understand the point. So it's as simple as this. If for example, there are a huge number of offshore generators off the coast of Northumberland, and somebody comes along and sets up another wind farm or whatever, and that potentially leads to congestion. That's the sort of thing that you say it's intended that the regulator has the flexibility to impose charges for related to congestion as a disincentive to that particular generator.
Exactly, my lord, and it doesn't require them to do so, but it leaves the flexibility if they wish to do so. So, my lord, in the impact assessment, page 20, you have the heading tariff harmonisation, and so that you have your bearings, that's part of a section dealing generally with problem definition.
Well, that point isn't at the bottom of page 20.
Exactly, my lord. Exactly.
Yep.
That's exactly it. And the same point, my lord, emerges on page 25. Again, under the heading transmission tariffication, and this is dealing with objectives. So you have that the need for fair, cost-reflective, transparent and directly applicable rules applies equally to transmission tariffication, must be non-discriminatory tariffs, must be cost-reflective. The objective of the regulation is to achieve a certain degree of harmonisation to avoid distortions of trade. Specifically, the aim is to facilitate efficient utilisation of the interconnected transmission system. However, and I underscore this, it is also necessary that member states be able to implement tariffs which encourage efficient network utilisation within their borders. So, my lords, that is the balance. So I say, taking the impact assessment and the guidelines together, the starting point, before we venture into the quagmire of the regulations and directives that came later, is that the drafters of the ITC regulation specifically envisaged, I say, that charges relating to the management of congestion internally within a member state were not to be harmonised, and they were to be carved out in the exclusions alongside connection charges, charges for losses and other ancillary service charges. Can I show you very briefly how GEMA put that point in its own decision so that you have it for your note? That is in Supplemental Bundle 2 at tab 14. And picking up Annex 1, if I may, which is at page 271. My lords, this is GEMA's legal analysis underpinning its decision. And within that, there's a subheading, if your lordships have it at page 273, just above paragraph 14. Do pursuance charges fall within the scope of the ancillary services exclusion? Paragraph 18, they answer the core question that I'll come to shortly. Are these sorts of charges which are for services necessary for the operation of a transmission system? Answer, yes. And then they ask themselves, is this conclusion supported by reference to the travaux préparatoires? That's paragraph 19. And then at paragraph 20, they draw precisely the conclusions that I've just been outlining to your lordships by reference to the impact assessment, the use of the word congestion in the 2005 guidelines, and then in subparagraph E, the indication that the Commission wanted to facilitate pricing models which enabled the sending of locational signals. So that's
The whole of Annex 2 was based upon an assumption that you don't consider the 2019 regulation.
that's right, my lords. But
If you don't do that, one can see why this may stand up. There's nothing to contradict it.
and the but is obviously the critical but one of the submissions I'll be making and developing shortly is when you come to ask, well, what is the 2019 definition doing in those additional words? Is it bringing about a fundamental shift from the position as it was understood at this point, and as in my submission is then reflected in the 2009 definition taken on its own terms? Answer in my submission, unlikely. Or is it adding clarification that in fact is consistent with the entirety of that history, and that is dealing with congestion management in the very specific sense of the capacity allocation process?
No, it doesn't say so.
I'll walk you through, but my lords, how it is I get to that conclusion. But this is the first step of that analysis. Just one sidewind just to complete the picture before I turn to the 2009 regulation. The guidelines did note, and this is back to the guidelines in Supplemental Bundle 1, behind tab 1, that there should be consideration in future as to whether there should be greater harmonisation of transmission tariffs. And your lordships have that point on page 6 of the guidelines in the penultimate paragraph. Charges covering costs of losses and other ancillary services can give short-term locational signals. The need for eventual harmonisation regarding these charges should be investigated in detail in the future. Now, my lords, when it came to the recast legislation in 2019, the Commission did consider again whether there should be full harmonisation of generator charges, including all charges for ancillary services. And in fact, as I'll show you in a second, they referred in that context to pursuance charges. And the upshot was no, not full harmonisation, not at that stage. My lords, you have the impact assessment, or an extract from what is a phenomenally long impact assessment that led to the 29 regulation behind tab 6 of this same bundle.
Sorry, I've lost the bundle.
It's supplementary bundle 1, tab 6. Page 99, Lords, you've got a summary table showing you the different options that were being considered at that stage, from business as usual through to full harmonisation of transmission tariffs. And I just want to show you one short passage. If you Lords have, your Lordships have page 104, halfway through that page between the hole punches you'll see a heading comparison of the options. At page 106, you then have a italicised heading harmonisation. This is where they're assessing should there be full harmonisation. And then on page 107, the critical passage, beginning with the first full subparagraph, There are two sub-issues that have also been considered as part of this option. Should we harmonise charges relating to ancillary services and grid losses and locational charging? The Commission notes a significant diversity in charging methodologies with regards to ancillary services. In most member states, all costs for balancing services are recovered via charges on suppliers. Only in a few member states do generators pay grid charges that comprise a specific contribution for balancing services. And there's a footnote 33 there, my lords, which refers at the very end of the footnote to the position in Great Britain, where those costs are recovered through BCOS charges, split equally as they were called between generators and suppliers. And then the paragraph continues, if charges for ancillary services were to be harmonised, the impact on short-term and long-term electricity system efficiency would depend on the level of the charges, so on and so forth. And then the conclusion in the summary over the page, my lords, under the heading summary. Given the overwhelming complexities in this field, it is concluded that the most appropriate option is to leave full harmonisation for the future, either as part of a network code or amendments as the position may come. So there is consideration in 2019, my lords, should there be further harmonisation, and specifically should that extend further into ancillary services charges.
Sorry, am I missing the congestion charging? Issue is that what they mean by locational charging here? I.e., give incentives for people to locate in places that don't contribute to congestion.
In part.
So that's the paragraph that you didn't read at the top of 108.
And I think, in fact, that that's considering a slightly more developed point of the same principle, which is should there be further sending of locational signals. So there are two distinct issues here. Should there be harmonisation in relation to ancillary services and grid losses? And that's the point I was showing you in 107. And then there's further consideration, should there be harmonisation in such a way as to send further locational signals, further locational charging? And overall, as I say, under the summary, the conclusion is no, not at this stage.
It means not full harmonisation, because it might be said that switching the balance of internal congestion charges into the charge as opposed to into the exclusion is not full harmonisation. It still leaves a vast amount to be worked out and left to the national authorities.
My lord, that's right, I accept that. The only point I take from this is that certainly so far as we could discern, there was no intention at the time of the 2019 regulation to fundamentally interfere with, restructure, alter, amend the degree of harmonisation that's set out in the ITC regulation. The question was left over, should there be further steps taken in the future? So be it. My lords, from that starting point, can I then turn to the question, what is the natural and ordinary meaning of the words that are found in the 2009 definition, and of course retained as the opening section of the 2019 definition? I'll take this very shortly. Your lordships will probably have them well in mind by now, but if you wanted to bring them before you, they are in Bundle Authorities 1, behind tab 2. At page 33. And it's subparagraph 17 on the left-hand side. So ancillary service means a service necessary for the operation of a transmission or distribution system. And my short submission, my lords, is this, and it's a very simple one. The natural and ordinary meaning of those words alone would include paradigmatically all of those services provided or procured by the national system operator, which are necessary to keep the system stable and secure and within safe limits. And on the face of this language, there is nothing to drive or permit the court to distinguish between different types of support services, and no reason to do so. And I say, my lords, that's unsurprising given the practical point I made to you at the outset, that the same services are used in practice to address multiple issues at the same time. So pausing, my lords, before we embark into 2019, the position your lordships is left with is this. I say if you look to the original guidelines from 2005, internal congestion management charges were intended to be within the scope of ancillary services charges, and so carved out from harmonisation. If your lordships then ask, looking at the definition as it appeared on the face of the 2009 legislation, the position is completely consistent. Looking at that definition, internal congestion management would naturally, indeed paradigmatically, be an example of an ancillary service within that definition. And so the question for your lordships is there a change in 2019? And it would have to be, my lords, a change that is explained nowhere insofar as we can see the recitals or the background material, and certainly Mr. Beale identifies nothing for you that explains why the definition is being changed. And when your lordships stand back to assess, is there a change, there are multiple factors that will go into your lordship's assessment. All of the linguistic points that Mr. Beale took you through this morning as to references to congestion that might be read as extending to internal congestion. But also, more broadly, the structure of the 2019 legislation and the focus on capacity allocation as the relevant form of congestion management, as I'll show you in a moment, the definition of congestion itself, and then standing back and looking at the definition of ancillary services as a whole as it appears in the recast legislation. My headline submission, my lords, is this. When your lordships stand back from the argument and look at the structure, the text, the purpose of the recast legislation as a whole, it becomes apparent, reading it against its history, that the additional words introduced in 2019 are clarificatory additions. They do not alter the substantive effect of the original definition of ancillary services. What they do, and all that they do, is to confirm that on the one hand, the internal services which transmission system operators such as the National Grid procure in the market to maintain the operation of the transmission system in their own internal member state remain within the definition. And on the other, the specific and separate capacity allocation congestion management process set out in the recast regulation does not. Lords, can I take the structure of the regulation first? And my submission is this, that this is a regulation, the 2019 regulation, which makes specific and direct provision for congestion management through the auction process that is known as capacity allocation. And my lords, will be coming to the text of the regulation, which is behind tab 7 of the first authorities bundle, but just to address the points of principle first. Day in, day out, my lords, every member state in Europe, national system operators are taking steps to keep their transmission systems in balance and within safe limits and to stop cables overheating and everything else that I touched upon. And up to a point, the EU has left that process to national operators. But the EU has recognised that certain structural, i.e. recurrent, congestions within individual member states can have a particular impact on the internal market, and that a coordinated EU response is necessary for that category of structural congestions. And the way in which the EU legislature has covered that territory over time, my lords, has been by subdividing the internal market into particular network areas. Initially in 2009, reflecting member state boundaries, and then in the much more sophisticated market as it stood by 2019, these entities known as bidding zones, which in some cases are simply member state boundaries, in some cases are multiple member states, and in some cases are subdivisions within member states. So it identifies those network areas. It requires member states to work out the total capacity on the links that join those different network areas. And then it establishes this auction process under which market recipients can request that capacity through a market-driven auction process. My lords, if we pick up the 2019 regulation behind tab 7, highlight certain passages in it. Recital 9 on page 287, my lords. You see there that regulatory frameworks have developed. That development has been supported by the adoption of several network codes and guidelines. They provide provisions, and what is noted here is that to ensure full transparency and increase certainty, the main principles of market functioning and capacity allocation in various timeframes should also be adopted pursuant to the ordinary legislative procedure and incorporated into a legislative single act, and that's what's being done here. At recital 16.
Did you say recital 7 that was?
Recital 9.
9, I'm sorry.
So sorry.
16.
16 then, my lords, notes the regulation from 2015 sets out detailed guidelines on cross-zonal capacity allocation and congestion management in particular markets, and again I underscore the linkage of those concepts. At recital 19, over the page on page 289, we have here bidding zones. Bidding zones reflecting supply and demand distribution are a cornerstone of market-based electricity trading and a prerequisite for the full potential of capacity allocation methods. They should be defined in a manner to ensure market liquidity, efficient congestion management, and overall market efficiency. Recital 33, over a further 2 pages to page 291. This regulation should lay down basic principles with regard to tariffication, like tariff setting, and capacity allocation. Again, that is the focus, whilst providing for guidelines into the future. At the top of the next page, 292, recital 38, there should be rules on the use of revenues from congestion management procedures, unless the specific nature of the interconnector concerned justifies an exemption from those rules. And as I'll show you as we chase through the provisions, those are revenues from the capacity allocation process. And then straight diving into the body of the regulation, at page 309, my lords, network access and congestion management, that is the chapter heading, that is that with which this section is concerned. The structure here, my lords, is Article 14, bidding zone review, and what is happening here are provisions that go to where should bidding zone boundaries be drawn and how should you identify what the most economically suitable place is for those boundaries. And then having established your bidding zones, into Article 16, general principles of capacity allocation and congestion management, and I say again, my lord, those concepts are expressly linked. Subparagraphs 1 and 2 make some introductory and general observations about the need for non-discriminatory and market-based solutions. And GEMA understands those to be references to cross-zonal congestion management, i.e. capacity allocation.
Sorry, I've lost your paragraph.
Article 16.
Article 16, page 311, my lord, paragraphs 1 and 2.
Thank you.
But in any event, paragraphs 1 and 2 are but basic principles as to non-discrimination and so forth. And the remainder of this article, almost 2 pages of it, is focused on how member states are to identify capacity on the connections between different bidding zones and how they are to auction that capacity. And I say that follows from the linkage of congestion management and capacity allocation in the heading of the article that you saw in the recitals, and in fact in a handful of other places. The 2 concepts are being used together. My lords, if you then look to Article 18, page 314.
You say that Article 16 is concerned with capacity on interconnectors and how to allocate it. Does it also deal with capacity on the networks themselves? I'm just looking at Article 16.4. What lies behind your submission, and Mr. Beale accepts, of course, he makes the opposite point, is that the regulation deals at great length with congestion management. And we can see here that it does. How does that then tell us whether it's ancillary or not? We know that it's dealt with. What is the nexus which then takes us to the answer to that?
It's coming at it from two directions at the same time, my lord. If you start from the proposition I invited you to start with, which is that at every stage up to this point, internal congestion management will be treated as an ancillary service. The question then is, when you see a carve out in the amended definition saying excluding congestion management, what does that mean? Does it mean the internal services, the internal congestion management with which pursuance charges are concerned, or does it mean congestion management in this very specific EU-driven capacity allocation sense? My submission is it's the latter.
So Article 16 for the maximum level of capacity of the interconnection and the transmission networks affected by cross-border capacity. How do you construe that? That's referring to both the interconnector and then the transmission network affected by cross-border capacity. But if the system that's being described covers capacity management on both the internal system and the interconnector, that might suggest a shift in policy. This is a much more comprehensive set of rules than anything which preceded it.
But my lord, that breaks down, because if you then look to paragraph 5, for example, capacity shall be allocated by means of explicit capacity auctions or implicit auctions. Now, that simply doesn't happen, certainly doesn't happen within Great Britain. That allocation of capacity is at the interconnections between different bidding zones.
Yes, okay, that's what subparagraph 5 says.
Exactly.
They exist in the same interconnection.
I absolutely accept, as the judge accepted below, there are references in this morass of material to the position with internal member states, although not quite as many as I would say as Mr. Beale reads, and principally directed to how they bear on the internal market and its functioning. But I do say that Article 16 is overwhelmingly and principally concerned with congestion management in the specific sense of capacity allocation, and that is what you worked through in this detail. My lords, if you could turn then to Article 18 at page 314. And this is the provision regulating charges for access to networks, use of networks and enforcement. Just to add another piece to your jigsaw. These are the core principles as to the setting of domestic transmission tariffs, and you see all of subparagraphs 1, 2, 3, 4 are concerned with setting the charges for network access in a particular member state. And indeed, in paragraph 3, that where appropriate, those tariffs may take into account the amount of network losses and congestion caused, and investment costs for infrastructure. But then in paragraph 5 of the article, my lords, a specific distinction is drawn again, as between all of those costs and the charges resulting from congestion management, as referred to in Article 16. So setting the charges for network access under this article shall be without prejudice to charges resulting from congestion management referred to in Article 16. I say it's just another indication that what is happening in this regulation is a distinction between the position being dealt with in individual member states and the specific congestion management referred to in Article 16, which is capacity allocation. And there are, in fact, my lord, separate rules as to the use of congestion income in the sense of income resulting from capacity allocation under Article 19 that you have at page 315. And that is in effect a waterfall of ends for which those particular revenues can be or should be allocated. So income revenues from capacity allocation, again, specific and distinct treatment, reflecting, as I say, the scheme of the regulation as a whole. So drawing those strands together, my lord, if you ask what is the particular form of congestion management that this regulation is overwhelmingly concerned with, It's the congestion management of greatest significance to the internal market, i.e. that between bidding zones that is managed by the capacity allocation auction process.
Can we just take it back to 16.1? And just ask what is the subject matter? So it starts, network congestion problems shall be addressed with non-discriminatory market-based solutions. So that's a generic statement which give efficient economic signals to the market participants and transmission system operators involved. I mean, it doesn't say interconnection operators. Network congestion problems shall be solved by means of non-transaction based methods and so on. What the reference here to, I mean, this is one of those overarching provisions, and it refers to network congestion. Now we've seen there's no definition of network, but if there is a definition of interconnector and it doesn't use the expression interconnector. And I see what you say about the importance to which is being attached in this to interconnector, but the question, even on Mr. Beale's broadest definition, it covers everything, interconnector plus, so there will be provisions on interconnector. How do you construe 16.1?
There's two answers to that, my lord. GEMA's position is that the network congestion problems being addressed in 16.1 are the network congestion problems of greatest concern to the internal market, i.e. congestion at the boundaries between bidding zones. And that is to what these are directed. But my lord, there's a second answer, which is that even if you took the contrary conclusion, even if you accepted, as Mr. Beale invites, that this is about all network congestion problems anywhere they may arise, that doesn't detract, in my submission, from my broader point, because all you see in paragraphs 1, 2, 3 here are some very general, generic statements about non-discrimination, the use of market-based methods and the like. When you get to the detail and the substance of the provision, it is capacity allocation. Well, could we then turn to the definition of congestion at page 297 and just unpack a little what that means?
I'm sorry, it's yet one of those dog with a bone type moments. If one goes back to 2009, in the 2009 regulation, congestion, which is on page 7, that bundle, tab 1, 22C. Congestion means a situation in which an interconnection linking national transmission networks, okay, that's an interconnector, cannot accommodate all physical flows resulting from international trade requested by market participants because of a lack of capacity of the interconnector. But then there's the and or, so that the cause of the problem at the interconnector is internal. So it may, in order to remedy that problem, you can't just remedy the interconnector, can you? You can't just say, well, we'll allocate bidding capacity at the interconnector because the problem doesn't arise there, or does it?
My lord, there's two answers to that. First, focusing on the structure of the definition, and this is a point made by the CMA. You first ask by stating the question, well, what is the situation which is congestion? Congestion means a situation in which, so what is that situation? And the situation is where an interconnecting cannot accommodate all physical flows. So the situation which is congestion is where the problem is on the interconnection. Now there's then a question, what has caused the problems on the interconnection? And that might be a lack of capacity on the interconnection, or it might be a problem within the national transmission system. But those are the reasons why that situation has emerged, and it is the situation very specifically which is the definition of congestion.
Well, is this a definition with one part to it, which has got, it's about where it arises and its cause. That's congestion, isn't it? The situation would include A and B, wouldn't it?
But Lord, in my submission, yes, but it must be A and B. If you just had a position, to test it this way, if you just had a position where a national transmission network could not accommodate all of the relevant flows for whatever reason, that would not be within this definition. That is across through A, even if you find the same words in B. And my lord, I do say, in fact, that informs, again, the submissions I've been making about what congestion management means, because
So if a given interconnect, going back to my example of GB and Ireland, if the interconnectors can't accommodate the demand, so that's congestion as defined there, and that may be caused by the fact that the interconnectors themselves lack capacity. There just aren't enough of them, or they're not big enough, or whatever. But it may also be caused by the fact that there are problems with a lack of capacity of the national transmission system.
indeed, my lord, and the example that I think by recollection the learned judge gave below in argument was, if you imagine a tailback of the Dartford Tunnel, it might be caused by a problem internal to the Dartford Tunnel. It might be caused by an issue in the land adjoining the Dartford Tunnel. What matters though is whether, applying that here, whether the problem is the situation in which the interconnection, in that example the Dartford Tunnel, can't cope with the flows. It doesn't encompass.
So you would submit that if what one has is a purely internal problem that isn't affecting the interconnector between GB and Ireland at all, that's not within this definition in the 2009 regulation, and you say, for reasons you've been developing, doesn't fall within the 2019 regulation either.
Precisely. And I'm certainly not going to take you through it, but you no doubt noted already in the 2009 regulation, Annex 1, you had a set of guidelines on capacity allocation on interconnections that was effectively the predecessor to what becomes Article 16 of the recast regulation. So from that background, turning then to the definition as it stands on page 297 in the recast legislation, I say all that has happened here is that, reflecting the fact that we have moved away from capacity allocation as between member states only to this more sophisticated system of capacity allocation between bidding zones, you see the consequential update to the definition of congestion, that it is still the situation, but the situation is now that requests to trade between network areas can't be accommodated because they significantly affect the physical flows on network elements which cannot accommodate these flows. I said it's the same
to 22C, isn't it? Sorry, it's very difficult to 22C of the 2009 regulation.
I wouldn't go so far, my lord, it's an updating of 22C.
It doesn't. It's now trade between network areas, not trade across interconnectors.
If it said trade between bidding zones, you'd be home and dry on this point, but it doesn't.
Indeed, my lord, I accept that.
So one does ask oneself the question, why does it use the phrase network areas?
Well, one answer to that, my lord, is that as you've seen between 2009 and 2019, this is a market in which there is vast amounts of structural change, and we have gone from capacity allocation as between member states to this system of bidding zones with all of the complexity that entails. And all that network areas is doing is reflecting bidding zones as they stand at the moment, but no doubt future changes as they may come. This is about trading between those areas within, or as between which there is capacity allocation. My lord, I do
In the
also...
old days, we'd have referred this to Luxembourg.
Indeed.
Surely, and we'd also probably have sent a letter of request to the European Commission for guidance on what happens in other member states. We used to do that quite regularly. And it's the sort of thing there ought to be an answer to. You've got vague language, can be argued both ways, but there is certainly some consistent practice being applied. You can't do that anymore.
Unfortunately not.
We do this now.
Can I give you another factor to have in mind as you put your finger into the air, looking at the definition in these terms?
But the definition of structural congestion here doesn't seem to be limited to congestion that causes a problem either in an interconnector or at the, as it were, the junction between different areas.
No, absolutely not, my lord. And the reason for that is that structural congestions within the internal market as a whole, but which would include internally to a member state, are what drive where you draw the lines for a bidding zone. So in Article 14, where you see the rules for bidding zone reviews and how to analyse where should bidding zones be subdefined, that's done by reference to structural congestion. But I say that doesn't detract from my overall position, because that is, one, it's a separate definition, but two, it is driving to identify the bidding zones which are then used for capacity allocation. But my lords, just focusing for a moment longer, if you'll let me, on the definition of congestion itself, I do say that it's instructive to test it this way. Every aspect of that definition makes sense if congestion is that which is managed by capacity allocation. So looking at the different elements, market participants make requests to trade, that's the bids through the auction process. They're looking to trade between network areas, between the different bidding zones, and there will be cases where there are too many bids and the requests can't be accommodated, and they can't be accommodated for the specified reason. So if you test it as against capacity allocation, it makes sense. But none of those elements naturally apply, in my submission, my lords, to wholly internal congestion. Market participants, certainly in GB, do not make requests to trade. Trade is unconstrained. There's no question of putting in a bid and seeing if you're successful or not.
No, sorry. Just say that again.
Certainly within GB, my lords, market participants do not make requests to trade. Trade is entirely unconstrained. There's no system for making a request to trade that could, quote, not be accommodated. If the system is overwhelmed in GB because of internal constraints, the trades continue. The operator, GESO, has to control inflows, outflows by all of the package of services that we say could, ancillary services. And most significantly, perhaps, my lord, test this on Mr. Beale's approach. If he is right, and that a network area means simply any place in any network, you might as well strike those words through completely. This should, on that analysis, be a definition under which trade cannot be accommodated. Network areas and the reference to trade between network areas is entirely superfluous. But there's no reason, my lords, to think that they're surplusage. They add something, and what they add is that this definition is concerned with congestion between network areas, i.e. I say between bidding zones.
But I mean, what you're describing there is really the trade that, and I follow your point about that it doesn't require requests as such. I mean, the word request then suggests something that's happening across national boundaries, effectively. Requests from generator in one country for supply of electricity from another. But if you look at it simply in terms of trading within England, say, or within England and Scotland, then generator A in, say, in East Anglia asking generator B in Hertfordshire for electricity is hardly between network areas, really, is it?
Exactly, my lord. It's hardly between network areas, and in any event, there's no question of it not being accommodated. Trade is unconstrained, all the trade happens. The question then becomes, what do you do to solve the problem that is caused by that trade? So I say, breaking down the definition, it's consistent with GEMA's approach to what is meant ultimately by congestion management, and it simply doesn't work in my submission on Mr. Beale's approach. I won't take you back to it, but for your note in this context, my lord, this is the analysis that you find in the CMA's decision, particularly in paragraphs 8.54 to 8.57, which is tab 24 of core bundle 3 at page 708. And my lords, in the briefest of terms, that is also consistent, for what it matters, with the retained law version of this regulation and the definition as it appears now in the present day, under which congestion is very clearly interconnector congestion, as the CMA explained. My lords, finally, before I hand over to Mr. Hickman, there's this final point, which is that I say all of those submissions are further supported by looking at the structure of the expanded definition of ancillary services itself. So, my lords, you have that definition, if we just have it back before us,
I'm sorry, Ms. Rogers, so just looking at the retained, the regulation behind tab 8, the retained EU legislation regulation. Definition of congestion at page 373. A situation in which an interconnection linking the GB transmission network with the transmission network of another country or territory cannot accommodate all physical force resulting from international trade required by market participants because of a lack of capacity of the interconnectors or transmission systems concerned. I mean, that's a completely different definition. Somebody is, for once there has been a change in the wording.
Well, there has been a change in the wording, my lord, although in fact what it's doing is reinstating part of what you saw in the original 2009
Well,
definition.
it's reinstating part of 2009, but it's making it clear that certainly so far as the retained EU law regulation is concerned, it's dealing with trade across international boundaries.
Precisely, my lord, and all I say, and this is the extent of the submission, is when you chart the line through from the 2009 definition through to the 2019 definition through to this retained law version, on my submission they speak with a single voice, which is that all of this is concerned with, in inverted commas, cross-border trade that by the time of the 2019 regulation includes cross-zonal trade between bidding zones. It's not about internal congestion within a member state. So, my lords, finally looking at the definition of ancillary services itself, so
Just to, when EU retained law became EU retained law, the government had the ability to do two things. One was to just, if you like, constitutionalise it. Such changes that were necessary to make it constitutionally equivalent, remove references to community agencies and that sort of thing. But it also had the ability to change the law. And that was of the essence to the whole concept of EU retained law. And it's what the government is busy thinking about at the moment in all sorts of different areas. So there are two ways of looking at this. Either it's the government confirming your construction of the legislation, but actually taking quite a different, using very different language to that in the 2019 recast, or it's changing the law. I suppose you don't mind.
well, I say squarely the former is confirming my construction, and Mr. Beale's clients themselves say in their skeleton argument, this is not intended to change the position.
But
It's
you
just
one doesn't know that. I mean, in my other role at Locational, we come across this very regularly. You know, we're looking at all sorts of things relating to retained EU law, and it's not easy to say sometimes whether the government has deliberately changed it or not. It all went through at such breakneck speed, but they did on occasion. Is there anything in the admissible material for construction of EU retained law which affects this? I mean, it all went through at such breakneck speed. There was most of it went through by negative or affirmative resolution, and so very little of it was actually debated in committee or in any way.
the answer to that, my lord, is I'm not sure that there is. I wonder whether those behind me could just check the explanatory note as I complete these submissions, which may be the answer to your lordship's question. But certainly nobody is putting before you any material that suggests that there should be, it was intended to be a change. So, my lord, this final point as to the definition of ancillary services itself. So here we're in the recast directive, which is Authorities Bundle 2, tab 9, at page 565. And it's two very short but related points about that definition, my lords.
Sorry, we're in the recast, did you say?
In the recast directive, it's tab 9 of Authorities Bundle 2, internally at page 565. So my lords, you see the additional words including balancing and non-frequency ancillary services, but not including congestion management. So two related points about those additions. One is that the definition expressly recognises that balancing and non-frequency ancillary services are ancillary services. They are within the definition. And you had my submissions to the effect that the services that address constraints, many of them are either balancing or non-frequency services. But even leaving that aside, my lords, even if that were wrong, these additional words cast light, I say, on the type of services which are to be treated as ancillary services. And those are services that are used to ensure the safe and stable functioning of a transmission system. And I say it would be logical to treat all services driving at that end to the same way. Certainly there's no logical reason for treating them differently. And if I am right, and this is the second point, my lords, if I am right that congestion management is dealing with cross-zonal capacity allocation, then this definition is simply...
If you go to the retained law version, that incorporates the definition of ancillary services from the recast regulation. And it says excluding, but not including, congestion management. But given the definition of congestion at page 373, that can only mean management of congestion across or between different countries affecting international trade.
Precisely, my lord, and that's the submission. If I just take a moment. Just to my Lord Green's question about the retained law version, I do this in two stages. Mr. Molyneux behind me notes that in core bundle 1, behind tab 5, you have Mr. Beale's skeleton argument.
Hang on a moment. Core bundle 1.
Tab 5, below page 104. That gives you what is said in the explanatory note to the regulations. They're made in order to address the failures of retained direct EU legislation.
Where are you reading from?
I'm so sorry. Footnote 35, my lord, at the very bottom of the page.
Well,
So I've got
so just to find
this-
where it's a footnote 2.
Is this, which document is it? Respondent skeleton, is it?
This is SSE's skeleton, core bundle 1, tab 5, page
I've
104.
taken it out, I need to find it elsewhere.
I'm sorry.
Yeah. Yep.
Lords, unless there's anything further, those are my submissions.
I want to ask an impertinent question. You may remember the old, many years ago, the European Court delivered a judgment called Schwarzfeld, in which it said that members, in the part of the duty of cooperation between institutions of the EU and member states was that the institutions would answer questions posed by national courts. We can't do that anymore. Would the Commission answer a question if we were to pose one?
I simply don't know the answer to that as I stand here, and we can certainly look at it and come back to the court.
I mean, it would be, if we were trying to seek a uniform interpretation so that this country was not adopting an entirely inconsistent construction to other member states, and it's in everybody's interest to have the same rules, then there may be evidence that the Commission could provide on the way in which it was supplied in other member states and whether or not it was excluded or not. Should be.
It wouldn't affect the point about the retained
No.
law version, because that seems to me to stand or fall on its own, but it would affect the 2019 regulation.
My lords, as I stand here today, I just don't know the answer to that question, but if we could take it away and potentially even liaise with the government legal department in order to give your direct
the
answer.
Commission wouldn't necessarily say, oh, you're no longer a member state, we won't cooperate. They may well say, well, we would cooperate with the third country with whom we were interlinked and for whom there was there was a uniform interpretation. So, for example, generators on the continental and Scandinavia or wherever were not prejudiced by having an inconsistent interpretation of common legislation. And so far as I understand footnote 35, I think it's saying, well, I'm not entirely certain what it's saying. To Mr. Bill's skeleton. It's planned. These regulations are made to address failures of retained direct EU legislation to operate effectively and other deficiencies. I mean, are they saying that there was a deficiency in the definition that we're concerned with, and therefore they've changed it, or are they saying, well, I don't know what they're saying.
But on any view, my lord, the indication is no impact assessment is required because no particular impact is anticipated, which rather suggests they're not envisaging a fundamental change.
They said that on virtually everything under the sun because it got them out of producing an impact assessment. They had to say that, otherwise they were obliged under internal domestic administrative rules to produce impact assessments, which there was no way they could do in a million years. I'm not quite certain. How do you interpret the explanatory note?
We say all it means is that moving to a position that the UK is outside the European Union, these are drafting amends necessary to make the definitions make coherent sense in the situation we are in now, which is simply updating what you see in the 2019 regulation so that it refers to the position of GB now, which is trade across interconnectors, as you see reflected in those words. It's no more, no less than that.
Have we actually got the explanatory note?
You don't, my lords, but I can certainly ensure it's provided.
These notes weren't drafted by Parliamentary Council, they were drafted generally by the departments themselves as they were put through, so that they're of limited assistance, both explanatory notes to SIs. But well,
Perhaps you could liaise, all of you, with each other on this point. One of the things I was going to say at the end of the hearing is that you won't be surprised to hear that we'll be reserving our judgment, and you probably won't be surprised to hear that we are not going to undertake that you will have judgment by the end of next week. so that we have a little time. I'm not giving you open season to take the whole of the month of August answering this point, but we certainly give you 14 days or something. But if you can agree something, put in something short as agreed.
Certainly.
That would be helpful. Thank you.
and of course if we have different submissions on whether we should do it, that of course is up to you.
It will be done. Thank you, my lords.
Thank you very much, Ms. Rogers. Yes.
Thank you, my lords. Well, I in the light of those superb submissions, I can be relatively short. I only have a few additional, very short additional points I wanted to make, and then I want to, if I may, take a couple of minutes to reply on the first ground. Can I just on the last point that that was raised about the change that was made by the post-Brexit implementing regulations. Can I just refer you, it may be helpful, to page 143 of the core bundle. There is a table which replicates a table that's included in the CMA's decision, paragraph 3.42 of the CMA's decision. You have the evidence there. And so you have it in two places. You have it in the skeleton argument. You also have it in the CMA's decision itself. And what the CMA did was it set the different definitions, the most material ones, ancillary service and congestion, side by side. That is the 2009 regulation, and the 2009 regulation definition comes in via the directive and the 2019 regulation. And then what it's done is it has crossed through the provisions in the definition of congestion that have been taken out by the implementing regulations. Exactly, and it just highlights the submissions that my learned friend has just made, that there is a commonality of approach. There's no substantive difference in terms of where we've ended up, and you may say, well, what weight can be given to those amendments? The CMA mentioned them. It's recognised that the amendments were not determinative, but they gave comfort to the CMA in the interpretation it had reached on the basis of other reasons, and in my submission that was a legitimate thing to do. Secondly, the CMA relied on the inclusion in the 2019 definition of ancillary services of balancing and non-frequency ancillary services, and for the reason that Mr. Rogers has given, that is another firm indication that the sorts of charges or the sorts of services that we are considering as being included within the definition are comfortably within it and are exactly the sort of thing that ought to be included. And it's only the external congestion, as it were, the external congestion charges that is carved out by the reference to congestion management. It doesn't, as it were, gut the ancillary service definition or ancillary service exclusion. Now, Mr. Beale says, well, what's the commercial rationale for drawing the line between internal and external congestion? The answer is the one that you've been given in terms that emerges from the Travaux and the original documentation that underlay the 2009 regulation, which was the need to incentivise and therefore the location of generation, and therefore to include it within the excluded charges. And that gives you the answer to that question, and that is why also it's clear that the balancing services and non-frequency ancillary services are also comfortably within the exclusion. The other factor that was relied on by the CMA, of course, in its decision was the original definition, and the original definition has attracted some discussion, but I did just want to mention this distinction that's drawn by the CMA between cause and effect, because it is important, because it's true that although the cause of congestion might be internal, so it's not just a problem with an interconnector itself or a transmission line itself. It had to be an interconnector obviously back in 2009, but it could be an internal congestion. It's only when there's a problem with moving electricity along that line that it becomes congestion within the definition. And in fact, you've been given an analogy. I wasn't aware of the Dartford Tunnel analogy, but you could think of a bridge, for example, and essentially.
When you say moving electricity on the line, along the line, you mean along the line between two countries?
Yes, an interconnector, but it's now not limited to interconnector, of course, because it could be interconnectors are lines between member states within the definition, and so it could be a connection between bidding zones. But if you have, for example, a bridge, there are two reasons you might have a problem getting people across the bridge. One is the bridge is not wide enough to get all the people across, or it may just be that there's too many people trying to get over the bridge at the same time. And they're the two scenarios that my law picked up, that's referred to in the original definition of congestion, the and or. But has to be a bridge, and the problem has to be getting people over the bridge. If there's not, you're not within the definition. And there's no significant fundamental change going to the 2019 regime. It's all of a piece. It does become a bit more complicated with the multitude of references to congestion in different contexts, but they don't, in CMA submission, change the essential point. So my lord, that's, in the light of the submissions that's been made, that's all I think I need to say on that point. Can I just very briefly reply on the first ground? I mean, in our submission, there was a certain unreality in the submissions that are being made by SSE on this point. One has to ask, what is the relevance of the connection exclusion definition? What's its purpose? The relevance of the definition and its purpose is as part of, and only as part of, a calculation required to ensure that the aggregate transmission charges stay within the permitted range. It is somewhat odd, to put it mildly, to contend that it's unlawful to amend the CUSC to include a definition which is not fully compliant, where the purpose and effect of that is to avoid the permitted range being exceeded. In circumstances where that's the only purpose and effect, the only purpose and relevance of the connection exclusion definition is to ensure that very thing, or that very range, is observed. Now, my lords, it's been suggested that the situation can be characterised as GEMA moving from a position that was not lawful towards a position that was lawful, or non-compliant towards a position that was compliant. We submit that's not the correct analysis. We submit that it's not correct to characterise the starting point as an unlawful or non-compliant position. And my understanding of the submissions that have been made by Mr. Beale is that he agrees with that submission. He emphasised that it's his submission that the starting point was compliant, because he said you don't have to incorporate the regulation. It's directly applicable. So that's an important point.
Not certain I understand. Let's assume the regulation is directly applicable, it binds everybody. Never mind what's in the code.
Yes. So the starting point
So
before...
the charges set by National Grid have to comply with it.
Yes, they do, but they always did comply with it. So there was never a non-compliant situation.
They excluded certain costs. They were within the permitted range, but certain costs were either included or not included, as the case might be.
Two critical things. First of all, the permitted range was not exceeded, which is the obligation. And secondly, as Mr. Bill has described it, an ad hoc process of making sure the permitted range was not exceeded. Calculations were being done. So there was not a starting point position, as it were, of non-compliance or illegality.
Yeah, I mean, you say it was always all right on the night at the end of the annual period because somebody did a computation and checked that the ranges hadn't been exceeded. It might not have been a very visible one, but it was done.
You ask yourself what the duty is. If you're asking whether something's lawful, what's the duty? There was no duty that was not complied with, because there was no... The duty was to ensure the aggregate average charges stayed between the permitted range, which they did, and there was no duty to incorporate. So there was no duty that was breached in the starting point position. Okay? Now, I'm not saying necessarily that's an ideal situation. Obviously, better that there's a process incorporated into the CUSC.
Do you know for certain I mean, one of the complaints that Mr. Beale makes on behalf of his clients is that the NG process was lacking in transparency. They had concerns that the costs were not being properly allocated. I mean, does anyone know for certain whether there was compliance or
We
not?
were shown the passage in the GEMA decision at 269, where they say there had been, in effect, historical compliance, and that's what they've been told by National Grid.
Yes.
But we don't know.
Well, I'm only speaking for GEMA, so my submissions are, from our perspective, that's the analysis. I mean, I can only speak for GEMA.
I mean, it may just be a matter of characterisation. The general position was there was a risk of imminent and serious breach.
Yeah.
And that was the position. Whether maybe it's going too far to say there was proven illegality or unlawfulness or improper charging, but they were of the view there was something to be remedied.
Yes, there was, but there hadn't been any breach. There was a serious concern that there was going to be a breach of the permitted range, which is why they took the step they did, and they agreed the original proposal. So they've acted to avoid a breach of the regulation. That's why I say it's bizarre to say that that somehow puts them in breach of it. It doesn't. So what duty is it that's said to have been breached here? Well, Mr. Beale suggested that by reference to the Zerbone case, well, if you're going to implement a regulation, you've got to make sure you do it appropriately. Well, you need to make sure you don't frustrate the achievement of the regulation, which they didn't. They did the opposite. It's then suggested that there's some duty arising from a public law, domestic principle, about error of law, misdirection of law. But there was no breach of any domestic principle here. There was no error of law. This is addressed in the CMA's decision at 5.145, page 633. Don't need to turn it up, but it's there. They address that and they say there's no error of law. GEMA are perfectly well aware of the deficiencies here. That doesn't mean it's unlawful. And okay, the amended CUSC could potentially, down the line, have created an unlawful consequence if it resulted in the permitted range being breached, and it would have been the upper level being exceeded. But that was not an imminent prospect. Indeed, GEMA's position was that there would not likely be any breach of the permitted range within the next 2 or 3 charging years. So
I'm sorry to interrupt you.
Yes.
This is the point you're making here, that all that was required was that the charges were within the range, and the generators like SSE were not entitled to say, well, I'm entitled to have my charges, as it were, fixed at 1.72 or something. As long as they were between 0 and 2.5,
Exactly.
then there was nothing they could complain about.
Exactly.
Well, actually, they couldn't even complain whether their charges were outside the range, provided there were enough other people whose charges were
Yes,
inside.
yes,
So
yeah.
the average
Well, that's
overall
to
was,
bring the
yeah,
average.
precisely.
Exactly, that's the point.
Yeah.
I mean, yes, it was an imperfect solution. Yes, it needed fixing, but they were doing it to ensure compliance with the regulation, which they did, and so there was no illegality. One way to look at it, or
Well,
to
the
think
effect
about
of
it,
going back to the point you made right at the outset of
Yes.
your submissions, the effect of an over-inclusive approach to the connection exclusion was that less went into the charge than would otherwise have done.
Yeah.
If they hadn't done that, then more would have gone into charge, which would have increased the risk that they were going to go, that on average it was going to be above 2.5, and that was precisely the imminent risk that GEMA identified.
well, the imminent risk was they were going to go below.
It's going to go below.
Go
Bottom,
below, sorry,
bottom,
go below.
yes.
Sorry.
And I showed you the table. The table shows you that that with the amendment they made, although it had an incorrect definition built in, they were going to stay within the permitted range. But if they hadn't adopted it, they would very likely have crashed out of the permitted range. So what they were doing was ensuring compliance with the law. And just finally, I mean, one way to think about it is an error of law. It's not any mistake, misinterpretation of a provision of law or contract which renders something unlawful. It has to be material. What's the material error here? What was done achieved compliance with the regulation. And my Lord Justice Green said there's no challenge here to the regime, and something we would say respectfully endorse. It wasn't suggested, and it's never been suggested, that the CUSC requirement of better facilitation is itself inconsistent with EU law. That's never been suggested. My Lords, unless there are any questions, those are my submissions.
My Lords, very briefly in reply, I have a handful of points only. I did say I would come back on the capacity guideline, the CACA regulation, and whether it was retained EU law. It's not. It's gone. So that's my homework over lunch.
So we can ignore that one.
My Lord, no, because it was applicable at the date of the decision.
Applicable at the date of, yeah, okay.
But since we have an ongoing situation, can they take account of it in the future?
Going forward for the future, it's part of a suite of legislation that previously informed the interpretation of EU law, but they've chosen not to retain it.
That's for JR round 5, I think.
Not for now, I think. I don't have a formal right of reply on the main appeal, and I don't intend to exercise it, if I may, save for 2 points of fact and one mild complaint. The points of fact are, it was said by Ms Smith for GEMA that I hadn't raised the ex post reconciliation point with Mr Justice Swift, which I'm afraid is simply wrong. I looked over the shorter German at paragraph 16.5 of the speaking note that I handed up to Mr Justice Swift, and which I recall vividly he complained bitterly about.
I was about to say.
It was too long. And he said, "You've given me more homework, that's not welcome." But he was definitely taken to it. And if necessary, I can provide you the transcript. I don't think any of this matters, but I just want to correct the record.
No, okay.
The second point is, my learned friend Mr Hickman said, we didn't contest the suggestion that this was lawful at the first stage. Now, it may be I've misunderstood his first stage. The first stage, of course, was when there was no implementation of the connection exclusion definition into the CUSC at all. So my submission has been, well, there's nothing to gainsay the direct application of the ITC regulation in that situation. It is clearly my case that with the approval of CMP 317 and 327, that built in the illegality, the unlawfulness, which was the incorporation of an incorrect legal definition. So it's wrong to say, therefore, if that's taken at the first stage, and I'd understood my Lord Justice Green to, with the staggered implementation point, the first stage is getting it wrong, but only a bit at stage 1, but then curing it in due course in stage 2. And if that's the first stage, then we very much say that that was an illegality and unlawful. So it may just be a miscommunication as to the label that's being used. The third point, and a mild complaint, is the materiality point's never been raised. It's never been suggested that this is an immaterial error of law. There was no finding to that effect by the CMA, and it hasn't been raised as a ground of appeal. So, with the greatest respect, it's not appropriate in a reply when I have no right of reply to raise that point for the first time. Can I then move on to what I am lawfully entitled, permissibly entitled to reply on, and that's the cross appeal. It was suggested that balancing and congestion management have common systems. The reason I took you to Mr Tyndall's evidence, in particular paragraph 4.7, which you will recall, that's page 295 of core bundle of Supplemental Bundle 2, tab 16, was because he identifies specifically which pursuos costs are an issue. And he recognises that not all of the pursuos costs relate to congestion management. Some of them do, and those are the ones that are an issue. So we are dealing with a subset of pursuos costs that relate to congestion management only. In any event, balancing is dealt with under the BSC code. And so it's BSC charges that are raised in respect of balancing costs. So, at least in part, or for the most part actually. So the terminology and the suggestion that this is all in practice merged is with respect not right. And of course, Mr. Self, in that paragraph 38, I think it was, of his witness statement, recognises that the grid itself has a flag which tells you whether it's congestion related or balancing related, to the extent that there is conceivably any overlap, but we don't understand how that necessarily works. It's within grid's purview. As a matter of fact, balancing is for the system as a whole. It's demand versus supply, demand versus generation within the network as a whole to maintain the frequency of the network. Congestion management, as I indicated in my main submissions, is you're looking at a particular bottleneck within the infrastructure of the transmission system itself, and that has to be cured. So they're dealing with two separate functional issues.
Wouldn't you have, if you didn't balance the system as a whole, you'd end up with congestion?
If you didn't balance the system as a whole, you'd end up with system failure, because the wires would collapse, because you would have different frequencies, different allocations, different voltages kicking off. You can have the system as a whole that is integral because it's balanced, but you have a problem getting flow through a particular bottleneck. And that's the difference between the two. The similarity, and I accept that there is a similarity to this extent, is you're paying generators and demand different sums in order to rectify a problem. It's a different problem. What we then see a reference to from Ms. Rogers is the ERGEG guidelines. They didn't deal explicitly with the question of whether or not congestion management was an ancillary service. What they did deal with was whether transmission charges that were levied by network operators, transmission service operators, on generators for congestion constraint management were within what they called G charges. That was their conclusion, and they said ordinarily G charges aren't included in transmission charges. Sorry, congestion management charges aren't included in G charges or transmission charges for generators. What then happened is that regardless of whether or not that was right or wrong, the Commission in the Commission Impact Assessment, that's this Supplemental Bundle 1, tab 2, page 20, took a different view. And so we see in Supplemental Bundle 1, tab 2, page 20. Right at the top of the page. Tariffs are the charge for local system users for use of the transmission system. So just pausing there, insert Article 18 of the recast regulation. So that's what we're dealing with, access charges. The main elements of the tariffs represent the cost of investment and operation and maintenance of infrastructure considered to be fixed in the short term. In addition, the costs of managing congestion on the system are also met by TSO. Tariffs are paid to the TSO to whose system the user is connected. Those are all G charges. Those are all transmission charges. They are charges for access to the network. So the basic premise behind the ERGEG assertion was then gainsayed by the Commission, who said, well, look, actually, what's happening here is costs of managing congestion on the system are met by the transmission operator, and moreover, tariffs are paid by virtue of your connection to that transmission network. So whatever may have been going through the specialist body's view when promulgating guidelines, the actual body that's responsible for proposing and then passing the ITC regulation has formed a very different view.
Now, this is the internal staff working document.
It is, it's an impact assessment.
It's an impact assessment.
Which under the better regulation equivalent at EU level is part of the requirement.
I was struck by the fact it's I think a 2010 document, although it's COM 2008, and the document we've got in the papers hasn't got its final numbers. I mean, it's COM 2008 XXX final SEC 2008, but at the top Brussels SSE 2010.
Yes.
Do we have a date for it? Did it always remain a draft? Because normally Commission working documents have their own internal definitive number.
They should do, and they should have done, and this must have done, but I don't know why the draft we have here doesn't have.
I think it would be useful just to know what the date of this was. Not necessarily now, but
I think we do have some more homework anyway as to what you might ask the Commission on a phone a friend exercise.
I know that once in the House of Lords being asked about what would happen if you phoned the Commission, to which the answer was green sleeves.
Translates very well into French and German. So that's the impact assessment for the ITC itself.
But just what are you effectively saying that this is a reference to the Commission concluding that congestion charges are included? Is that what they're saying in terms?
Well, they're not saying that in terms. What they're saying is, contrary to the premise that lay behind the OGEG guidelines that, I mean, ultimately the point from the OGEG guidelines that I understand what Learned Friend principally draws upon is the suggestion that G charges don't include charges for losses, congestion and other ancillary services. She also makes a point that, well, other ancillary services might suggest that losses and congestion are ancillary services, but actually they're not. But putting that to one side, the key point she draws from it are that these aren't included in G charges and therefore they wouldn't be treated as a transmission cost, transmission charge. Whereas in fact the premise lying behind the Commission's assessment of the position was that the costs of managing congestion on the system are to be met by the transmission operator.
So how is that consistent with the adoption of the guidelines without any mention that they've taken a different view? Page 44, 45.
Because there is no, the guidelines themselves are at page 7.
Yes.
And they are referring to charges paid by generators related to ancillary services or any specific network losses. And the Commission hasn't taken the view that congestion management charges paid to a national TSO are within the scope of ancillary services or network losses.
So as I understood it, your point was the Commission at page 20 had taken a different view from that expressed in the guidelines.
Well, they just don't seem to have assumed, unlike OGEG, that these would be included in transmission charges. But the point is that the exclusion for congestion management isn't actually found in page 7 of the guidelines. So it's entirely consistent with that the Commission is recognising that whatever they may have said about these not being included in G charges, it doesn't find its way into the express ancillary services exclusion, which deals only with losses and charges paid related to ancillary services. And what we don't find in the ancillary services exclusion in the ITC regulation is the references to network losses. So the addition that's made in 2019 inserts the reference to network losses and makes that an ancillary service, but makes it clear beyond doubt that congestion management is not included. Having used, the ITC regulation used a generic term, ancillary services, you have my submission that in fact that bears a specific meaning within the industry, etc., etc. But putting that to one side, the clarification that comes later in 2019 is to both re-include reference to network losses, which are in the OGEG guidelines, but to exclude congestion management, which isn't mentioned. The next factor to take into account is the impact assessment for the actual recast regulation. My own friend took you to that. It's in tab 6. Please can we pick it up at page 101. So this is the recast directive and the recast regulation as a single impact assessment.
Sorry, page
101. And third paragraph down, it says more specific requirements are provided for under the inter-transmission operator compensation system, the ITC regulation. So it's recognising that the ITC regulation exists, This regulation sets down limits on the average annual transmission charges. The regulation also required ACER to provide an opinion, which it did on the 15th of April. That opinion, we then see in the next paragraph, recommended that G charges based on energy produced should not be used to recover infrastructure costs. Just pausing there, that's because they were recommending capacity-based charging rather than flow-based charging, as I understand it. There's no suggestion that G charges shouldn't be charged to generators. And then energy-based G charges should be set at 0. So this is a recommendation to get away with generator charges as full stop, except where they are used for recovering the costs of system losses or costs relating to ancillary services. So again, that's tagging back into the actual wording of the ERGEG guidelines as formulated. But lest there was any concern that that might encompass congestion management, of course the final version we get is that that excludes, as an exception to the exclusion, congestion management is the exception to the exclusion. So it's putting it beyond doubt that what they have in mind as being within the basket of ancillary services exclusion is system losses or costs relating to ancillary services. And that ties in then with the amended definition that's given. We then see page 102, just to clarify, when it's looking at deficiencies of the current legislation, it's not saying this is a fundamental, radical reappreciation of where we've been. It's recognising there's significant scope for national differences and how the distortionary impacts can be resolved, but the ACER recommendation has, i.e. for full harmonisation and setting at 0, has not been implemented into the ITC regulation. So whatever ACER may have suggested going forward, that wasn't the view that was then followed. And obviously there is a rationale to that, there's a coherence to that, which is congestion management is part of transmission costs incurred by a transmission services operator which is charged to generators. And that pass on of that cost should properly be included within average annual transmission charges because it is a cost that generators face. And that then feeds into the market harmonisation, soft harmonisation approach in the ITC regulation itself, because it's part of the suite of charges that generators do in fact pay. And Muller and Friends' submission on interconnected congestion didn't grapple with the point that if it is only interconnected congestion, and it's only capacity allocation that we're talking about, then that's got nothing to do with generation charging full stop. And so the words simply don't make any sense. And in essence, she has to be driven to capacity allocation as the solution for all of the ills of congestion in order to avoid the suggestion that there is a relevant basket of generator costs which have to be considered. Now, Muller and Friend also suggested that congestion or constraint is part of the locational approach to charging. With the greatest respect, that's not right. Congestion or constraint charges are reflected principally through the redispatching process I've identified. They are payments that are made to generators to shut off generation in one area and to increase generation in another in order to overcome the blockage. Those are costs that are incurred by the generator because they have to pay out money, and those costs are then put into a basket of charges that then goes into the relevant CUSC charging system. Those charges are not going to be individually calibrated for the location of a given generator, save that a payment is made to a generator in a given location. But the charges themselves, once they've been incurred by grid, are going to be spread as CUSC charges that won't have a locational element to them. Now, in contrast to that, you do have locational charging for system losses. And the way this works is I think there's 15 or 16 designated areas in the UK, in GB, which are identified as zones for charging. And each of those have a locational element to them. And the distance that certain generators are at from key areas of demand is then used for a nodal analysis. So every particular entry point onto the network is subject to a nodal analysis as to what particular contribution to system losses that generator makes at that point. And that is then factored into strongly positive charging, as in high costs in Scotland, and strongly negative charging in the southeast. That is locational charging. That is for system losses. That is not the system that is applied for congestion or constraint management. My learned friend said, well, look at Article 16, it's all about capacity allocation. You've already got my submission. In fact, Article 16.1, 16.2, 16.4 and 16.13 are nothing to do with capacity allocation. They are to do with congestion management more broadly. The next argument was cause and effect. You have my submission that that's wrong. Congestion is the problem. That problem leads to an impediment to trade flows, and that is a concern. But it's physical congestion that is the problem, or structural congestion that is the problem. Using the CACM tripartite division of market congestion, physical congestion, and structural congestion that I took you to, they're all congestion. The only one that's linked to an interconnector is market congestion. And that's because that's then linked to the capacity allocation process. But everything else is congestion. And it's simply impossible with respect to factor in interconnector congestion as being what congestion is about and plug it into every other situation in which the term arises. And that, of course, means that you don't have the harmonised approach to the construction of the same term across different EU legislation that is the crux of EU interpretation, resulting from the three cases I took you to earlier. Now, it's true that structural congestion can be solved by bidding zones, as Ms. Rogers said, but of course it can also be resolved by other congestion management measures, which are the very thing that the TSO here grid puts in place. The next point was request to trade. It was suggested that somehow that's a link to the auction process. With respect, that's not right. The auction process that deals with capacity allocation requires somebody to bid for an entitlement to be able to flow energy over an interconnector. And there's an auction, so you put in a bid for an auction. That's not the same as a request to trade, which is a request to do business buying or selling electricity within the internal electricity market. To make that good, if one looks at the recast regulation, so that's Bundle Authorities 1, tab 7.
It's the short point, a request for trade isn't necessarily over an interconnector.
Isn't necessarily
Over an interconnector.
No. No. If you're, in order to get, well, there's 2 points really. When we had an integrated electricity market, you didn't need to have a separate request for capacity allocation anyway, because it was all integrated in a very clever system. You simply put in a request to buy electricity from a German generator and you got it. In a divorced, non-unified market, there would be a need for a separate stage where you put in a request specifically as a flowing generator to get the capacity to enable you to flow your electricity over an interconnector to be able to sell it to the person who wanted to buy it. That flowing generator, i.e. based in another member state if they're flowing into the UK, would have to put in a bid for capacity allocation on the interconnector they wanted to flow in. But that, in any event, is not a request to trade. That's a request to get an entitlement to enable you to deliver your product. Now, if we turn to page 297, behind tab 7, of the bundle, in the recast regulation, you've already got my submission about market participant, and it's people buying, selling, generating, and so on. There's then a definition in subparagraph 7 of market operator, means an entity that provides a service whereby the offers to sell electricity are matched with bids to buy. So that, again, is dealing with an operator who's basically acting as an intermediary. But when it comes to trade generally, the only immediately obvious reference I can find to trade is at page 301, when dealing with the principles regarding the operation of electricity markets, plural. And under subparagraph P, it says market rules shall facilitate trade of products across the union, and regulatory changes shall take into account effects on both short-term and long-term forward and futures markets and products. There's no link there to the capacity allocation process. There is a trade in electricity across the EU because it's an interconnected system. Request to trade are requests for people to buy and sell electricity within the integrated EU system. Coming on to retained EU law, at page 373, the definition of congestion, has changed. It's true. And it's changed so that it refers to a situation in which interconnection linking GB with the transmission network of another country cannot accommodate all the physical flows, either because of a lack of capacity on the interconnector itself or from the transmission system concerned. So you can have a lack of capacity due to the transmission system, i.e. GB, leading to a result which is not congestion itself, but it's a situation in which you can't have the interconnection capable of accommodating flows.
It only applies where you're trying to have that international trade and you can't. Whether the reason for it is lack of capacity of the interconnectors or lack of capacity of the transition system concerned. But it doesn't apply when it's just simply internal congestion. It doesn't affect anything to do with international trade. It's just within the country.
But in an interconnected system, the lack of capacity in the transmission system is capable of having a knock-on effect on cross-border flows.
Of course, it's capable of having a knock-on effect, but this definition demonstrates that congestion, as defined, only occurs where it has an impact on the international trade.
Well, it is triggered when there's a situation in which flows across the interconnection can't be accommodated, but that's going to arise when you have structural congestion in the UK in GB network anyway.
Yeah, but you wouldn't bother putting a reference to interconnection linking in the Great Britain transmission system and all that word verbiage in if you weren't concerned with the effect on the interconnector.
But the effect on the interconnector can be produced by local GB congestion.
Of course, but unless you're trying to pass electricity over the interconnector, this just doesn't bite at all.
Well, my lord, I think what the UK government has done is it has simply replaced every reference to bidding zone with a reference to an interconnection. And they did that because there is only one UK bidding zone. I can make that good by showing you the implementation of, in this retained regulation, of Article 14 and Article 15. Article 14 deals with bidding zone review, page 412, and it's gone. Whereas it remains in place for Northern Ireland. And in Article 15, action plans which are designed to deal with potential bidding zone restructuring has gone, but it remains in place for Northern Ireland. Now in contrast, redispatching is dealt with at page 407, and that remains. And so where redispatching as defined is a method of dealing with congestion, see page 375. Top of page 375.
The previous page, 372, is definition of bidding zone, which was exactly the same. Yes.
So look, what I think we'd like, because we rather launched this on everybody at the last moment, and we'd like everybody to think about it a bit more. We'd like to know a bit more about the history of how the amendment came about, what that footnote 35 means, and we'd actually like to know what words were taken out and why, and how it compares with the position in relation to Northern Ireland, which may be like a comparative against which we comply. It's not sensible to do it at 4:15 on the second day of an appeal. And we think probably the best way is for you to set out your position upon it, and then for the respondents to respond to it, and then a short using Mr Justice Swift's perception of short, as anything under 50 pages. But anything you might want to say in reply, but I think we'd better have chapter and verse. So I know we're giving you a
Specifically on the
certain-
retained.
Yes, yes, we want to know how it came about, what it means, has it changed the position? Is it the government's view which supports the GEMA view, the CMA view of life, or is it just their constitutionalisation, which is taking out words, replacing them with other terms which are meant to be neutral, which really should take us back to the earlier definitions, but really to do it on the hoof in this way is not really going to help us very much.
Understood. Can I offer my 3 pennies worth on phone a friend? And that is that if in fact the question is referred by reference to the Northern Ireland Protocol, there may well be a provision in the Northern Ireland Protocol encouraging sincere good faith and cooperation, which the Commission would at the moment feel compelled to apply.
I think they might, as a matter of comity, they may
Yes.
be prepared to express a view, simply because it would impact upon international trades between the continent and Ireland and the UK, and that's in their interest to get right.
And given that the specific provisions dealing with electricity in Northern Ireland are part of the Northern Ireland Protocol where EU law continues to apply,
Yes,
and they want a level playing field, I think it's likely that they would want to see the same construction applied.
I suspect they would. But I mean, it
I haven't
won't be a
taken
matter of
instructions
duty-
on this.
It won't be a matter of duty of cooperation. It would be a matter of possibly under the protocol, possibly just, it's in their interest to get it right and to cooperate. My experience has always been that they're fairly cooperative in providing information to certainly national courts, but we ain't that anymore. But I don't think there's under the Trade and Cooperation Agreement.
Oh, I think there are actually, there's quite a suite of
So, I mean,
provisions.
this is, as my lord indicates, potentially an important point, which obviously, in relation to which there's going to be quite a lot of money to, so that we would like to have the assistance we've asked for and get it right, rather than trying to do with a deal on the hoof when the hearing is about to come to an end. So what I think would be sensible is in relation to the point about the Commission, I think I said 14 days. And if you can do a combined note, that would be very helpful. If for some reason you can't, then whatever differences there are can be put in short order in writing. Now, if you're going to put in something more short, but dealing with the issue that my lord just raised about the EU retained law version and why some bits have been taken out and other bits haven't, and definitions have been changed, what sort of timescale would be appropriate for that?
Well, I have a slight personal difficulty, which I'm reluctant to raise, but I'm off on holiday on Friday for 2 weeks, but
Well, you don't need to worry about that. It's about to be August before very long. But
if I could ask for
and I'm very
mid-August.
reluctant to leave it until September, of course.
But if we were to aim for sort of the 3rd week of August, would that be satisfactory?
Second 2 weeks of September. I think that's right. Okay. Well, we've just what we think would be sensible is we suspect that it may be necessary to have a short further hearing, and we've just been liaising with each other as to when that might be possible, so far as we're all concerned. It would only need probably to be an hour or at most an hour, and most 2 hours, I suspect, no more. But in the week of the 19th of September.
Forgive me for a moment for pulling on my phone.
And what we suggest is that if you can deal with the, as it were, the Commission bill by agreement within 14 days, that would be helpful. But so far as anything else is concerned, in terms of anything else in writing, we leave it up to the parties to agree between themselves and form the timetable, with a view to providing the court with the material in the previous week, say the week of the 12th, and having a short hearing in the week of the 19th.
Yeah, I hope a spirit of assistance for the court. If this court were to perceive a desirability for central government having involvement in some of these issues via collaboration with the CMA or GEMA, in my limited experience of dealing with these post-Brexit EU issues, that can require some time. I think
Well,
it's
it's
the
given you
neutral
the
way
best
of
part of 2 months,
yes.
even though it's a summer vacation.
I think it's enough time. I'm just saying if the court were to wish assistance in that sense.
We understand. And one of the things that occurred to me, and I remember as counsel being involved in these sorts of things, sometimes a government agency has a better entree to the Commission, rings them up. But if that's going to happen, which can be a good thing, all parties should be present on a conference call. So equality of arms throughout the process.
Yeah.
I'm sure that can be done fairly and openly. But sometimes it's better if one of the regulators does it, because you have an ongoing relationship with the Commission.
If we were to say that everything, including the EU Commission point, is to be dealt with by way of something in writing in the week of the 12th of September, with a short hearing in the week of the 19th of September, and if you could please liaise with the Court of Appeal Listing Office, I will warn them that this is coming, then I think that would cover your point, Mr. Gill.
Yes.
But if there are delays, I mean, who knows what's going to happen, and who's got to happen with government, who's going to be around, what ministers are around, so on and so forth. We'll have to play that by ear.
Yeah, and if there's a insuperable problem with that week, then we'll have to think about another week. That's just all three of us happen to be around and not engaged in other cases.
I was trying not to be rude, but I've experienced practical difficulties liaising with the government, for example, on state aid issues that I've been challenging, where it's sometimes quite difficult to get a civil
Well, it
government
may be
decision.
that a combined approach from the parties and their solicitors and counsel will help. Right. Well, subject to that, is there anything else?
No. Oh, I should say I misspoke. I said there were 15 zones. I'm told there were 27. So I don't think that's going to be the crux of the case.
Just get their views on the procedure.
Does anybody want to say anything about what we've proposed? I saw Mr. Rogers nodding, so I guess you thought that was fine.
We do.
Mr. Hickman, anything you want to say?
No, my fault, thank you.
Well, we'll leave it on that basis then, which obviously means that we won't be thinking about a judgment for the present. So I'll leave, as it were, the formal bits for the next occasion. If for whatever reason it turns out we don't need a hearing, I'll send you something in writing just to confirm what your obligations are in relation to things like the embargo on judgments, which has become quite an issue of late, as you may have seen. And I'm obliged to effectively give you your ticking off before anything goes wrong under the new system. So you can, that won't come yet, but it will come later. But in the meantime, can I just say on behalf of all of us, thank you all very much for your assistance and the high quality of the advocacy and all the help from behind. And for those of you who are going to have some holiday, I hope everybody enjoys their holidays and it's not too hot. Thank you.
Thank you very much.
All right.